If you've been injured on the job in Colorado, you're going to treat pretty much with a doctor selected by your employer and the insurance company. And at some point, that doctor is going to say, you are at what's called maximum medical improvement. You're as good as you can get. You're Humpty Dumpty, and all the king's men and all the king's horses have made Humpty Dumpty better again. Well, what if Humpty Dumpty doesn't agree? What if Humpty Dumpty thinks, I think they were wrong? We're going to talk about your rights when that happens. Hi, everybody. My name is Britton Morrell. I'm an attorney with Kaplan Morrell. We are lawyers in Colorado who have been representing injured workers for nearly now over 30 years. What we do is we help people who have on-the-job injuries. It's all we do, and we're very good at it. And thank you for joining us today on this topic. Please like, subscribe, and if you have questions regarding your case, feel free to get in contact with us with all the other ways that you can get in touch with us by phone, email, etc. So let's talk about division IMEs. I'm going to explain what they are, the 4 reasons why you may want to get one, how much do they cost, who has to pay for it, what are the risks to doing a division IME, what are the alternatives if you don't want to do a division IME, and why they're an incredibly important part of any workers' compensation claim in Colorado. Finally, stick to the end, and I'm going to tell you how the doctor that examines you is selected, and more importantly, how a great lawyer like us can help you get the best doctor possible to be the doctor who does your division independent medical exam, or D.I.M.E. So what are division IMEs, or D.I.M.Es? We call them D.I.M.Es, but it stands for Division Independent Medical Evaluation. And each of the words means something. Division means it's a doctor selected by the state of Colorado through the Division of Workers' Compensation. Independent means this doctor has not treated you and is not partnered with other doctors who have treated you. Medical and evaluation is exactly what it sounds like. It's a doctor who's just going to read the medical records and examine you, maybe ask questions, definitely ask questions, and give a report as to his or her findings. So that is what division IMEs are. When the doctor, the company doctor, has placed you at max medical improvement and said, here's your impairment rating, etc., and the insurance company decides to admit liability consistent with what that doctor says, it gives you a narrow window, literally a 30-day window, to decide whether or not you want to do a division IME. And it's an incredibly important decision. And doing it, not doing it, can have serious implications for your case. So let's talk about why you would want to do one. There are 4 reasons why you would want to do a division IME. The first one is you think you injured part of your body. Let's say you injured your knee and your low back, but the treating doctor or the insurance company saying, we don't think that you injured your low back. You only injured your knee. We're not giving you treatment for the low back. We're only giving you treatment for the knee. And if you want to fight that, you have to do a division IME. Reason number 2. Let's suppose there's some major medical care that even your own company treating doctor wants to give you, but the insurance company for some reason has denied giving you that care. For example, let's say, a doctor said, hey, I think you need a total knee replacement. And the insurance company had somebody look at it and say, no, not necessary, not related, whatever. And your treating doctor says, well, if they're not going to approve the total knee replacement, I guess that's all I can do. So you're at maximum medical improvement. Here's your impairment rating. You go to a division IME to fight to have treatment recommendations that your treating doctor or any other doctor has recommended should be given to you as part of your work injury. A division IME can make a big difference in getting that care. That's the second reason. Third, if you think for some reason the doctor has made a mistake in placing you at max medical improvement, that there's some sort of treatment out there that you think would be helpful to helping you restore and get closer to the way your body functioned before the injury, you need to do a division IME. Otherwise, you're stuck with the care that the doctor gave you. Last reason, 4th reason to really do a division IME is if you think the doctor made a big mistake in the impairment rating. Now, part of the reason that the doctor could have made a mistake in the impairment rating is because the doctor didn't give you a rating, didn't evaluate you for part a body part that you think is injured and the doctor didn't. But even if there's the same body parts, everyone agrees this is injured, etc., there are certain variations in how doctors do impairment ratings. They're done according to this book called the AMA Guides to Rating Impairment, but doctors do look at things a little different. Maybe they measure things differently. Maybe the doctor didn't do a proper range of motion testings. Maybe there's some part of your treatment that the doctor didn't take into account in giving you an impairment rating. In the guides, there are points of impairment you can get for having certain kinds of surgeries, certain kinds of symptoms, etc. And if the doctor doesn't give those to you and you think that they should, and if the guides give you impairment for it, then you need to go through a division IME to get that included in your impairment rating. How much do they cost? Going to a division IME is not free, and if you are the one challenging the treating doctor's opinion, then you have to pay for the division IME. If you're watching this video, you need to understand the prices I give you may have changed since I filmed this video, but generally the division IMEs cost between $1,000 to $2,000, but every year they're changing, so call us and we'll let you know how much division IME will cost in your case. And then it varies based on how long you've been treating, how many body parts are affected and you're wanting to have evaluated. And so in general, $1,000 to $2,000 is what it costs. Now there is a mechanism that if you are unable to afford it, can't do it, have no resources, aren't working, you can fill out a form called an indigency application that will have the insurance company pay for the division IME, but really what they're doing is they're advancing the cost of the division IME. The insurance carrier, in other words, gets to recover that cost later on down the road if you get more benefits. Now, we always hope when we do a division IME that our clients will get more treatment or more impairment. And frankly, that is the case about 70 to 80% of the time that our clients who go to a division IME get more treatment or more impairment or both. But there are a number of risks to going to a division IME that you should be aware of. The first one is the division IME doctor may determine that part of your injury, a body part that even the treating doctor, even the insurance company was saying, yes, this is related, this is work related. Yes, he did injure his left knee in the accident. Division IME doctor could say, no, I don't think so. So you run the risk. You run the risk of losing body parts, losing conditions, because the division IME says, no, I don't think it's part of the injury. Risk number 2. The division IME doctor may believe that you reached maximum medical improvement way before the treating physician did. So as an example, let's say the treating physician placed you at maximum medical improvement on July 1st of this year. You go to a division IME and the doctor says, no, I think you reached MMI April 1st. Well, if you received lost wages between April 1st and July 1st from the insurance company because you were treating, you had restrictions, and you were not yet at MMI, all of a sudden, those 3 months of payments now are considered an overpayment credit to the insurance company. So if you received, just throwing out numbers, $3,000 during that time between the MMI that your treating doctor gave you and the MMI that the division IME gave you, all of that money now is the insurance company gets to take a credit on and pay you that much less down the road. Risk number 3. The division IME could say, hey, I agree you're at MMI and I agree that your impairment rating is what the treating doctor said. In that case, you kind of wasted $1,000 to $2,000 and you've wasted some time going to this evaluation. But it is possible, again, one of the risks are you go to the division IME and nothing changes. Risk number 4. Division IME could determine that you have less of an impairment rating than the company doctor does. Again, let's say that your treating doctor says, I think you've got a 10% impairment rating. Division IME doctor could say, I think it's 7, or I think it's 0. That has happened as well. And that is another risk of going to a division IME. Now, with these costs and risks, sometimes, clients don't want to do a division IME, and that makes complete sense because maybe you don't want to spend the money. Maybe you don't want to incur the risks. That's, who knows? So what are the alternatives to doing a division IME? So there are a few of them. Okay, number one, you need to understand that if you do not do a division IME, you are stuck with the date of maximum medical improvement that the treating doctor gave you. The big impact or importance of that or consequence of that date of MMI is you cannot get lost wages after the date of MMI for what's called TTD, treatment total disability, okay? So I can't get my clients lost wages after MMI. So if you don't do a division IME, I can never get you lost wages after MMI unless you're permanently totally disabled. But that's a different kind of disability payment. It's very hard to get, and we have other videos on that. Okay. Here are your three alternatives to doing a division IME. There is a weird exception to the division IME, and that is if you injured only your arm or your leg, you could go directly to a judge and fight over what your impairment rating is without going to a division IME. But if you injured your spine or your hip or, frankly, in my opinion, your shoulder, you need to do a division IME if you dispute the treating physician's impairment rating. Alternative number two. If you have a hip or shoulder injury and the doctor is giving you an impairment rating for that, you can go to a judge without going to a division IME and argue that the judge use a different formula in calculating the value of the impairment rating to your hip or your shoulder. Now, I've simplified it quite a bit because it's not just hips and shoulders that are capable of what's being called converting the impairment rating. So if you have an impairment rating that's primarily to the arms and legs, even if it includes the shoulders and the hips, you could decide, I'll accept the treating physician's impairment rating for that body part, but I'm going to dispute the formula that was used. And you can go to court to dispute the formula that was used, but the numbers the treating doctor gave, those you can't change. Alternative number three. If the treating doctor has placed you at MMI and given you an impairment rating and you don't do a division IME and you accept that rating, you can later on down the road try to reopen your case to argue for a higher impairment rating or even the fact that you're no longer at max medical improvement if you can show your condition has naturally worsened. It's called a reopening. And again, later on down the road, if there's been a change in your condition since being placed at MMI, you can reopen your case and fight and say that you're no longer at MMI and you have a new impairment rating. Otherwise, what the treating physician said you have is what you're going to get. A division IME is a critical part of any injured worker's case, and the reason for that is because the law says that judges have to uphold the division IME's opinion unless the party challenging that opinion can show by clear and convincing evidence that the division IME doctor is wrong. That's really hard to do, not impossible, but very hard to do. And looking at all of the orders issued by judges since 2020, the judges have upheld the division IME's opinion 80% of the time. So if you go to a division IME and you don't like what the division IME says, chances are you're going to get stuck with it. So it's a huge, important part of any injured worker's claim. So I hope this gives you a good idea of what a division IME is, why it's important, what you need to do, when you should do it, and maybe when you shouldn't, or what are your risks. But what we haven't covered is how it is they're selected. And here's how an attorney can help you. What happens is you request a division independent medical exam, and the state of Colorado, through the Division of Workers' Compensation, is going to issue the names of 3 doctors. And what's going to happen is you're going to get rid of one. The insurance company is going to look at the other 2 and get rid of the other one of those 2. And whoever's left is the doctor that you're with. So you can imagine it's going to be really important to know who's on the good list and who's on the naughty list. And a good, experienced attorney like us knows who the good doctors are and the bad doctors are. We do extensive statistical analysis on all the division IMEs that have been done since 2004 to get a good feel on who are the good doctors for which kinds of injuries, for which body parts, for which kinds of impairment ratings that were given by the treating physician. And a good attorney is going to know also some stuff that doesn't quite show up in the statistics statistics. What doctors like other doctors? What doctors don't like other doctors? If you've got an impairment rating from Dr. A and the division IME is Dr. B, and you happen to know that Dr. B really likes A, even though they're not working together, but they're good buddies or they're excellent friends, etc., maybe you don't want B reviewing A's work. Or if you find that you've got a bad impairment rating for A and you know that B doesn't get along with A at all, in fact, thinks A is a clown, maybe you definitely want B to be the division IME. So a good attorney like us is going to be able to know the facts of your case, know the doctors involved, know the impairment ratings and the body parts, and be able to make sure that of the 3 doctors that are selected, we get rid of the worst one for you. And hopefully, the 2 remaining doctors are great doctors to evaluate your case. As you can tell, very detailed, very, very complicated, and you really need to know a lot of information in order to successfully navigate the division independent medical exam process. And that's why, if you've been injured on the job, you should be calling us. We're Kaplan Morrell. We've been helping injured workers since 1995. And we would love to be able to talk with you. As always, all of our consultations are free and confidential. And with that, thank you for spending part of your time with me.